Hello, everyone, and welcome to Uncivil Law. For today's case, we have a transgender situation in which a parent brought their child to the hospital because of a mental health episode. The child seemed to be a threat to themselves, and so they brought them to the hospital. Good parents. But after the threat had passed, the hospital refused to release the child to the parents. They refused to release the child, and so the parents are suing the hospital for doing this. They're suing them under state action theory, even though they're a private hospital, and also suing the government for their responsibility. So, what are the rules as it relates to this? What should the hospital have done as it relates to this transgender child, and what should parents do in the future? I guess don't bring your transgender kids to the hospital because they might not let them go again, would be a lesson one could learn. So, let's read this case and see what happened. When Joseph and Melissa Sieferts' child started experiencing thoughts, anxiety, and depression, they sought help. After first trying medication, they took their child, known here as Minor, to the children's hospital just outside of Cincinnati. And then eventually, the Minor ended up in the children's psychiatric facility. And after about a week, the insurance company determined that the Minor had no medical problems, so it denied further coverage. So the parents were acting responsibly. Their child looked like harm. They took him to the hospital. They were there for a week. The insurance said, there's no problem, so we can release this. Okay. The insurance coverage terminated. The parents decided to bring their child home, but not so much. They ran into a problem. Doctors and social workers would have none of it. So even though the parents were responsible enough to bring their child to the hospital in the first place, now that they want to bring their child back home, the doctors and social workers are saying, no, you can't do this. They're imposing on the limitations, even though there's no medical need. So that's not good. I don't think it says teenage child. Is this teenage child as specific as the court got? So I don't know anything more than that. Teenage child, whatever that means. Over the next 4 weeks, the parents wrangled with the hospital and the county, the government, about getting their child back. Only after the parents signed a voluntary safety plan did the child leave the facility. Well, one wonders how voluntary it is if they wouldn't let you leave, right? It sounds more duressive to me. The parents sued the county and its employees, as well as the hospitals and the doctors, alleging violation of the 14th Amendment's Due Process Clause, both as procedure and substantive. The district court dismissed the hospital because they were not state actors, and dismissed the county because it said they failed to overcome qualified immunity. So here we are in yet another qualified immunity issue, right? So as to the hospital, you can't get to them under the 14th Amendment because they're not state actors. As to the government, they are state actors, but qualified immunity. So the district court said, no problem. This is all good. What does the Court of Appeals have to say? But even a temporary deprivation of physical custody requires a hearing within a reasonable time. We, the appellate court, take the facts only from the complaint, accepting them as true, as we must, in a motion to dismiss. The parents have 5 children, one of whom is the minor in this case. The minor was born a girl, but now identifies as a transgender boy. The minor began taking medication and going through therapy in 2015 after reporting problems with depression, anxiety, and thoughts. After telling his parents about his identity, the minor emailed Hamilton County Job and Family Services claiming his parents were not supportive and their conduct amounted to abuse. This is when the county stepped in. So the parents were not doing what the government wanted. The parents were not behaving the way they wanted. So the government is now going to impose on them to make them do certain things the way the government wants. So that's not at all scary or dystopian or Orwellian in any way, right? That's when the county officials stepped in. Government is here to help. Rachel Butler, a job and family services employee, came to the home to talk on the same day of the email. 3 days later, acting at the behest of the pediatrician, the parents took the child to the children's hospital. The next day, the minor was sent to the psychiatric facility where the parents consulted with job and family services employees about the treatment. During a meeting with the parents, Butler explained the children would not be sent home without job and family services approval. So the government is stepping in saying they won't let this person in home. And that would not occur, they told it, until social workers were satisfied they found the right place for the minor to go. So that's all fun and exciting. The same day, a doctor presented the minor's case to another doctor with Humana Behavioral Health, who was covering the treatment, the insurance company. The Humana board certified physician concluded that the minor had no acute symptoms that required 24-hour care, and the minor was not in danger themselves or other, was not aggressive, was medically stable, and was not manic. So they denied additional coverage. So, they had 7 days of coverage. The physician working for the insurance company looked at it and said, there are no symptoms here. There are no problems, so we shouldn't keep paying for it because there's nothing to keep paying for. Let them go home, which seems fair enough, and that's what the parents want to do. They want to take them home. The next day, the parents began calling the children's staff members. This is Children's Hospital, that's why it's all caps. Children's staff members and leaving voice messages to exercise parental rights of the association with the minor. During this time, Job and Family Services, the government, was actively pursuing the case, but did not attempt to obtain a court order for custody or to provide them with the hearing that's required by law. Great. All the while, Butler and Stevens had their own telephone calls. Butler told Stevens that the parents could not take the minor home. That's when Stevens spoke with the parents by home. And when the parents told Stevens he wanted the minor discharged, Stevens said the child could not go home, and that the parents would have to contact Job and Family Services to get him out of the hospital. So the hospital is now interfering as well with this. So that's great. Then came the November the 28th meeting. It included the parents and Stevens. Butler participated by telephone. When the parents asked how to get their child discharged, Butler responded, "It doesn't work that way." Well, it really should. They were admitted, and one of the things you do after admitting is discharging. That's what you do when you release them. So the parents said, what's it going to take to discharge? They say it doesn't work that way. It kind of should. They're the parents. They're the guardians. They have the right. The child is not an immediate threat of anything. They have the right to take their child home. Why is the government interfering with this? Why is the government imposing on them? And when the parents cannot care for the child, the county must step in. What evidence is there that the parents can't care for them? What evidence is there of abuse or neglect or maltreatment? Nothing other than one email, which, doesn't seem to be validated by anything objective. Did we see any medical testimony about abuse or maltreatment or any of that stuff? No, we didn't see any of those things. So the government's just making stuff up for no reason. Unsatisfied with the meeting, the parent decided to email Hamilton County Administrator. That led to another meeting, this time at the Job and Family Services building in Cincinnati. The Butlers, the parents, and Eric Young with the Family Services attended. Young explained that Job and Family Services had to investigate and prevent parents from having custody or association with their doctors when doctors or social workers did not approve of the release. Young put it succinctly, we have to go by what the doctors say, which is really, really weird because the doctors are going by what you said. You're the one who's imposing on them. So the doctors aren't saying it, and in fact, the doctors are saying the opposite of that. And who is imposing on what? What's going on here? Who is lording over this and says, oh, we know better than you? The government knows better than you how to parent your own kid. This is government overreach. Is there any sign of physical abuse? No. Is there any sign of active neglect? No. Is there any sign that the child is misfed? No. Is there any sign of any of these problems that would lead to interference? No. And they brought the child to the facility, and now they won't allow them to bring it back. The government is imposing on them government will about how they should treat a transgender child. This is really, really scary stuff when it comes to this. The government is coming to people's homes and or preventing them from taking their child home because of how they perceive transgender rights should be. So this is like really onerous stuff and really scary stuff out there. The doctors made it clear. The doctor ordered that the minor should not be discharged on the request, and if they came around, security needs to be called. Fantastic. Finally, the minor left the children's hospital nearly a month after entering. The release occurred after the county and the parents entered a voluntary safety plan, voluntary, requiring the minor to stay with the grandparents. So, for some reason, these parents are being forced to give custody to grandparents rather than them. Voluntarily. Wow. The district court dismissed the motion and this appealed. So the district court apparently saw no problem with any of this. I see problems with this. I see lots of problems with this. It's interfering with parental rights. It's interfering with the rights inherent of a parent to parent their own child. There's no signs of neglect, abuse, maltreatment. There's nothing. So I don't see the problem, and this is really, really weird, man. Wow. This is so aggressive. And it just goes to show some of the concerns from the conservatives out there about some of this transgender rights. The conservatives are worried, in part, that the government is going to show up and demand that kids be treated a certain way. And this is evidence along those lines. So, it's really scary stuff out there. Why are they saying the parents can't hand them? I don't know. Reasons, Tessa, reasons. Now the appeal court has to analyze how this should apply to the defendants and if any cause of action is available. So let's read on. The defendants fall into two categories, the county defendants and the hospital defendants. The former argues that qualified immunity blocks their suit. Again, I am skeptical of qualified immunity, and this would be an example why. This would be an example why. You're actively interfering with the parent rights, and you should be held responsible for it if you're actively interfering without cause. And you didn't give a hearing they're legally entitled to, and you want to hide behind qualified immunity? Wow. And the hospital employees say the constitutional claims do not apply to them because they're not state actors. We begin with the state action, which would normally be true. Normally, private actors are not held responsible to the Constitution, right? Normally, only government is, or state actors. So we have to decide if the hospital is a state actor or not. So let's do that. Is the hospital a state actor? Let's figure it out. The 14th Amendment, like most of the Constitution, the 13th Amendment being the exception, by the way, places limits on government behavior and has little to say about what private parties must do. After all, the Due Process Clause protects individuals only from government and not private action, no matter how unfair it might be. But, like many things in law, the principle comes with exceptions. Sometimes non-government actors must comply with constitutional commands. When does this occur? Courts have highlighted several tests, but it all comes down to whether there is such a close nexus between the state and challenged action that seemingly private behavior may be treated as that of the state itself. So one of the things that you look to is the degree to which the private actor is in fact private as it relates to this action. So the most obvious example of this is if a police department wanted to hire a private investigator to do things they couldn't do. That's not going to work. By the act of hiring the private investigator, it becomes a state employee. It's not a police officer, but it's state employee enough. And so that is basically the line here. When the government becomes so intertwined with the private and that there's no ability to separate them anymore, at some point, you are now agents and servants of the state. And so it's like, okay, at some point, you have crossed the line and we can now treat you as the government. Did that occur here? The district court held that no such relationship existed here because Children's Hospital was simply performing medical treatment and complying with the Ohio reporting statutes. That would be the mandatory reporting statutes that require them to report certain things to the government. And Children's Hospital had no contact with the state, did not perform a state function, and the state did not approve of the policies in advance. So yeah, if that was what happened, then you'd be right? If all that you did was do the mandatory stuff you had to do by law, and you had no contact with the state, and you didn't have any contact with their policies, yeah, there'd be private action. Is that what happened here? But the Children's Hospital did far more than what the district court acknowledged. So the district court's statement of the facts leaves something to be desired on the record. According to the complaint, which we take as true, because that's on a motion to dismiss, so we look to the pleading, right? We look to the pleading. According to the complaint, Children's Hospital and the county worked in tandem, often collaborating and communicating about the minor situation. They depended on each other to block the release. Children's Hospital admitted it needed the county's permission to send the minor home. Meetings at the hospital often included the parents, the employees, and the county officials together. Children's employee told the plaintiff, the parents, that they could not discharge the minor without talking to the government. Indeed, when the parents demanded the discharge of the minor, the hospital told the parents that they would have to contact the government to obtain the discharge because the discharge was being blocked by the government. County defendants had, according to the complaint, told them that they could not go home. Stevens, the hospital guy, relayed the message to the parents, telling them the government holds the key in determining where the patient goes. And in his notes, the doctor wrote the Children's Hospital could not release it because the government gave clear recommendations not to allow the parent to discharge. So there's a little bit more here. There's a little bit more than just merely, oh, we didn't have anything to do with each other. No, it had quite a bit more to do with each other. You were talking to each other all the time. You're participating in meetings with each other. You put in your notes that the government was responsible for all this. So yeah, you were acting as government officials. I know you went to work thinking you were a private official. I know you went to work thinking, hey, my paycheck is being paid by a private entity. But you got so entangled with the government, you are now a government actor. Congratulations. You are a government actor. You are now responsible as though you were the government because you became so intertwined, we can't tell the difference anymore. So this is no longer private action, it's state actions. Congratulations, you passed the threshold. You're the government, you're responsible now. So yay, let's press on. The facts plausibly establish that the hospital state actor status because the conduct was attributable to the state. The state did this. This is the state's responsibility. You furthered it. It's state action. Congratulations. It is, of course, true. The mere fact that the hospital is licensed by the state is insufficient to transform it into a state actor. Yes, no one is disputing this. Mere licensure is not enough. Otherwise, every driver would be a state actor because this driver's license is issued by the state. I'd be a state actor because my attorney's license is issued by the state. No, mere licensure does not make you a state actor. Everyone agrees with this. Yeah, no problem. And the district court was correct that hospitals and doctors do not become state actors merely because they comply with state statutes. That's true too. So if that's all the hospital had done, or all the parents had alleged, then the children's hospital could prevail. But the parents present specific factual allegations detailing a deep and symbiotic relationship between the hospital and the county. From the perspective of the parents, it'd be hard to know who could discharge the minor, the county or the hospital. And when the distinction between the state and the private party breaks down to that degree, the private party becomes a state actor for the purposes of 1983. Welcome to the party. You are now the government. Congratulations on your governmental status. I bet you didn't know that was happening, but it's happening. You became so intertwined with the government, you became so hobnobbed, so friendly, well, you're basically now in a conspiracy. And what's good for one is good for all when it comes to a conspiracy. So congratulations. Welcome to the conspiracy. You are now the government. Congratulations. You are now responsible. So deal. All that means today is that the parents have alleged enough facts to keep the hospital in lawsuit. But the ability to survive the motion to dismiss does not necessarily mean they could survive summary judgment. They've unlocked the door to discovery, not to liability. And it may yet be shown that they were not a state actor. But at this point, it's too soon to know. Yeah, fair enough here. We're just on a motion to dismiss. So we need to develop more. The parents have alleged a whole bunch of stuff. And there's at least some evidence. But now we can get more evidence. For example, we can get depositions. We can get notes related to this. We can get all kinds of stuff that would tend to show this. We can get notes from the government. We can get depositions from the government. We can get notes from the hospital. We can get depositions from the hospital. You know, there's not even a medical privilege issue here because it's their records. So we don't even have to deal with the medical issues or HIPAA records because it's their records. So even that's not an issue because we can get all that stuff too. So we can get to discovery and find out who talked to whom about what. Are there emails? Are there phone calls? Are there phone logs? Are there who will testify about what? Who's going to throw who under the bus? Should be one heck of an interesting discovery, yes. But of course, now that they are potentially a state actor, we have to decide whether the hospital, the state actor, or the government, the state actor, can use qualified immunity. Is qualified immunity available? We love qualified immunity here on Uncivil Law, don't we? We love it when the government gets qualified immunity, don't we? Just the best thing ever. We love it so very, very much. So let's find out if this person can also escape responsibility because of qualified immunity. Is what the government did totally cool? Let's find out. Qualified immunity, pleading requirements, and the motion to dismiss have a complicated relationship. At times, we've said the court should refrain from using qualified motion at the motion to dismiss. After all, qualified immunity is affirmative defense, not an element of the cause of action. So yeah, this goes to the prima facie case and all that good stuff. Because qualified immunity is a something by the defense, whether or not you should bring it in has been an issue that courts have been struggling with. The known persona asks in chat, could an entity like Google become so intertwined with government they become a public entity? Potentially, yes. And then that raises like serious Fourth Amendment issues, potentially. Because Edward Snowden said that they've effectively been deputized by the NSA to see certain records. And so it might be the case that you could make an argument that there's such intertwined relationship between like Google, Facebook, et al. When it comes to being able to give or provide certain government records or conduct certain surveillance. you could make a non-trivial argument potentially that Google, Facebook, whatever, to the degree they're cooperating, and by there's cooperating and there's cooperating. So if we're in the second category, then you can make an argument that Google, Facebook, et al. Are actually state actors for the purposes of the Fourth Amendment. I don't know if anyone's actually tried that argument. I don't know if anyone's actually tried it. I don't remember anyone trying that argument, but it would be interesting to try. It'd be interesting to try to show they're so intertwined that Google, Facebook, whatever, stopped becoming a private actor and they're actually just the NSA. That'd be one heck of an argument. I don't think anyone's ever tried it, but could be interesting. We've also said the fact-intensive nature of qualified immunity makes it a bad fit for the motion to dismiss. Like our sister circuits, it is generally inappropriate for a district court to grant a motion to dismiss on the basis of qualified immunity. But this is only a general preference, not an absolute one. Defendant may raise a qualified immunity defense in response to the motion to dismiss because it's immunity rather than a mere defense of liability. So, with that premise out of the way, let's move on to the procedural due process. The states cannot deprive any person of life, liberty, or property without due process of law. To sue under the clause, the parents must have a liberty or property interest that triggers the process requirements, and they must show they received insufficient process. Well, geez, do we think we have a liberty or property interest in the care of one's own kids? I would say yes, probably yes. Let's move on. The parents argue defendants infringed on their right to care, custody, and control of their minor. And as the parents claim, the defendant did so without providing any process. That's what it sounds like. This runs afoul of the due process clause. Yeah, due process would tend to suggest some kind of process, yes. The parents claim because the parent-child relationship enjoys a deep and broad protection, and they got none. So it sounds like. When it comes to parents and their children, the courts are in unison. The relation gives rise to a liberty interest that a parent may not be deprived of absent due process of law. The Supreme Court has called parents' care, custody, and control perhaps the oldest of the fundamental liberty interests recognized by the court. This right is far more precious than any property right. Yeah, so children are a little bit more than just property. Yeah, the interest between parent and child is a little bit more than just in property. Yeah, so, the ability of a parent to raise their own child is a fundamental right. So the government coming and saying you must raise your child a particular way, particularly when there's not neglect, abuse, maltreatment, and all the rest of it, is seriously concerning. This looks like the government being too big brother. It looks like the government trying to impose its values as to politics rather than endanger the child. So this seems completely off point. The defense argue that their interest in protecting the minor outweighs procedural protections they otherwise would receive. Well, geez, we can do away with all that pesky due process. Why do we need any of that pesky due process, right? Why do we need any of that? The interest in protecting it is so interest that even though there is this built-in inherent, parent-child relationship, that isn't just something the law created. It's kind of deeper than that, even though we don't have to give any process of any kind because, reasons. We're the government and we know best. Wow. Just wow. The government and the government, because they're both the government, remember, the government and the government claim that the situation did not spark procedural requirements because the defendants were investigating potential abuse. Defendants never took legal custody of the minor. They kind of did. The parents voluntarily consented. And the parents never physically tried to remove their child. Yes, after you threatened them that security would stop them. Yes, they didn't try to physically remove their child. Wow, that's a really great argument, government and government. Totally persuasive. Eat it. The very least, defendants argue the due process rights were not clearly established so qualified immunity governs. Wow, yeah, your interest in your child was not a clearly established right at the time. Let's let that argument sink in for just a moment. No, but thank you for playing. These consent and abuse investigation rationales, however, clash with procedural posture. Yes, consent extinguishes safeguards. If you had consent, which incidentally, consent has to be voluntary. Otherwise it's not really consent. Consent under duress is not consent at all. So yes, consent would be fine. That's because hearings are required for deprivations, not for steps authorized for consent. If you had actually had consent, sure. And yes, a factual development might ultimately show that they consented to the hospitalization. So yes, it might be the case under the facts, once they're developed, that yes, they really did consent. Because that's a factual issue, right? But now is not the time for examining competing facts. It's time for accepting the complaint as true and drawing all reasonable. Doing so does not establish consent. Yeah, they had it a little bit over their head. You must sign this or else. Yeah, I'm feeling like if the plaintiff can prove all this, that they can show duress and coercion and extortion and all the rest of that kind of stuff. So, I'm thinking that, consent is not really here. It's not really consent. When you bludgeon them, you can't get consent by holding the figurative gun of the state to their head. No. The district court should have judged the complaint only, because that's normally how we do these things. We look to the complaint only. Just as in a prior case, the consent may become clear at summary judgment, which it very well may be, because at summary judgment we have a lot more facts. We have testimony, we have evidence, we have depositions, declarations, all that good stuff. So yes, maybe at summary judgment it'll become clear, but we're not there. But reading the complaint's facts in light favorable to the parents, because that's what we're supposed to do, because it's a motion to dismiss, we draw a reasonable inference that the parents did not give consent, given the number of times they alleged they demanded they be discharged. Yeah, I'm not feeling a lot of consent on that one, given the plaintiff's case, yes. Isaac Wicks. But, Your Honor, she didn't fight back. Yeah. Yeah, Isaac, that's basically exactly where we are. But she didn't fight back. The parents didn't try to physically take them. Yeah. Yeah, Isaac, that's basically where we are. They didn't fight back. Therefore, it was consensual. Yeah. Good job, government. Even so, could this all be clearly established to get around qualified immunity? Let's find out. This standard extends broadly to all but the plainly incompetent or those who knowingly violate the law. Well, I don't know, but I think we're kind of there. I think that it would be reasonably understood by everybody that parents have an interest in their child, and you have to be incompetent and or clearly in error to not realize otherwise. Yeah. A plaintiff can clear this high hurdle only when every reasonable official would know his conduct was unlawful, as established by controlling authority or a robust consensus of persuasive authority. We'll probably be okay there, yes. So it must be clear defendant's actions in this particular circumstance, as alleged in the complaint, violate the due process rights. You don't say. So in order for this case to go forward, it must be clear that the defendant's actions in this particular circumstance, as alleged in the complaint, would have violated due process rights. Plausibly, they did. Yeah, sounds that way to me. In case after case, the Supreme Court has emphasized that the parent-child relationship is special in our society. Yeah, we don't really need a case that says that. The parent-child relationship is pretty central and important, going back as far as, there have been parents and children. Kind of important, yes. This right's importance means that even a temporary deprivation requires a hearing within a reasonable time. Yeah, it's kind of important. A hearing is necessary when a child removal is sustained over objection. Yeah. And when state officials do not allow the parent to remove the child until defendants say so, that can be construed to be interference with custody. So yes, basically, the hospital and the government are guilty of kidnapping because they didn't give any of these hearings and stuff like that. That'd be good. Let's charge some people with kidnapping. Let's get some criminal cases in here for kidnapping too while we're in it. That'd be good. Let's do that because it seems like what's happening. In short, when the minor was hospitalized, the existing law placed the constitutional question beyond debate. A little bit, yes. At least that is according to the complaint. Defendants argue the plaintiffs, the parents, cannot overcome qualified immunity because no case says, wow, okay, I'm sorry, I had a brain stop because I was reading stuff and I was like, my brain stopped. So let's give that another go. Defendants argue the parents cannot overcome qualified immunity because, this is good, because no case says that parents deserve due process. When they voluntarily hospitalize their child, the state investigates allegations of dispute and the parents consent to ongoing hospitalization. Press X to doubt. But characterizing the case this way puts the cart before the horse. The complaint does not establish the depth of the allegations or that the parents consented to the ongoing hospitalization, because it sounds suspiciously like they didn't. The complaint says the parents routinely demanded that they be discharged, and the complaint alleges the insurance company had a psychiatrist determine that there are no harm. So that is the end of our coverage of the case of Joseph Serif versus Hamilton County. In this case, we learned the Serifs had a minor child, and they took the child to the hospital for treatment because of an ongoing mental episode. Like good parents did. They did it on the recommendation of their doctor. So their doctor said you probably should take him to the hospital. They did that. They're good parents, right? They took him to the hospital, and they were there for an entire week. And then a physician said, this person isn't really a threat to themselves anymore, so they can go home. But oh no, it wasn't good enough for these doctors. It wasn't good enough for this government, who then, according to the complaint at least, engaged in an ongoing conspiracy with each other to deprive this parent of their rights without any due process of any variety, even despite repeated demands. And the government says it's totally cool because, she never resisted, she shouldn't have worn that dress. So it's totally okay. This is totally legal. And no, none of these arguments make any sense. The parents repeatedly said, please let our child go. And they repeatedly said no. And they had multiple meetings and they said go. And they said security will be called and all the rest of it. So we will see what happens at trial. It will be really interesting as the depositions, declarations, the ongoing discovery of emails, phone calls, all that fun stuff occurs. It should be really, really entertaining as this case develops, because it sounds like the government decided to be really big brother about it. They decided that these parents were not being sufficiently progressive in their politics as it relates to transgender, and they decided to interfere on the parent-child relationship. And they're going to get smacked down, and smacked down hard. And I have no bad feelings about that. And that's the end of the coverage of this case for now. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.